All right. Good morning again, everybody. Paul Rabelais here. I'm an estate planning attorney. I work, out of our Louisiana offices. This is YouTube live presentation number 9 out of 20 consecutive YouTube live presentations. This one is all about how to quickly create a valid handwritten will. We get a lot of questions about that. Some people try to do it. And so this is all about whether you should do it, and if you do it, what are the rules that have to be followed, and how to do it as well as you can. So jumping right in, thanks Ron for the joke. We both looks like we're creating a bunch of dad jokes. As I heard, I've been accused of saying and writing dad jokes, which apparently your joke, my joke, appears to be kind of corny dad jokes. But nonetheless, if any of you have live chat or questions on the live chat, use the live chat. If you're watching this on a recording, feel free to put comments in the comments below. When I counted yesterday, it looks like about 1,800 views total of our first 8 YouTube presentations. I'm excited about that. Not big numbers for YouTube, but big numbers for estate planning presentations. So let's just jump right in. A little bit of a unique subject. If you go online, most lawyers are going to say, don't even think about doing a handwritten will. Don't even thinking about doing it yourself. Too many mistakes to be made, too many moving parts, need to work with a professional, need to work with a lawyer. I can't disagree with any of that, but I just know the reality is, in fact, with technology, more and more people these days are attempting to do these things themselves. In fact, they're trying to, on the medical side, diagnose their own, medical issues, legal issues. They're going online to discover what their rights and what they can do from a legal standpoint. And lots of do-it-yourselfers out there, and lots of information out there for do-it-yourselfers. So I know it's just a reality. Some people are out there doing wills themselves, not most, but some. And so this is just, if you're going to do it right. Yeah, there's a quote that says, the person who acts as his own attorney has a fool for a client. That's a quote we hear sometimes from the kind of don't do it yourself to try to resolve your legal issues. And we know estate planning can be complicated, but if you're like, I don't want to pay a lawyer, I'm not going to pay a lawyer. My situation is very, very simple. I hear I can do it myself, so I'm going to do it. Maybe you shouldn't do something like that without at least watching this video and perhaps even getting additional assistance. So with that being said, and all my disclaimers, let's jump right in. To my knowledge, 26 states that permit people to have handwritten wills. And actually, that's not true. All 50 states permit handwritten wills. It's just about half of them, the 25 or 26 that I go over, people can have a handwritten will with no notary and no witness requirement. The other states that don't allow that, your will could be in your handwriting because it has to be in writing, but you still have all of the notary and witness requirements that your particular state has. So I think the logic there of states permitting people to handwrite their own wills is, and not have any kind of notary and witness requirement is, perhaps the legislature thinks we want to make it easy for some people to get a will. We don't want to force them to go hire lawyers. And we realize that sometimes there are emergencies where people have to, get it done quickly. They're about to die, quite frankly, and they can't go through the exercise of hiring lawyers and scheduling appointments and all that kind of thing. So I think that's the basis for states allowing people to have handwritten wills. A question here. How does the probate court believe the handwriting is genuine? Does the testator have to leave a sample of his handwriting? Good question from Happy Me. And again, a lot of this handwriting will stuff is state specific, but I know in many states, if not all states, once a person dies, if they had a handwritten will, then something like 2 people who were familiar with the deceased person's handwriting have to sign an affidavit to be filed into the probate record that says, yes, I was presented with either the original or a copy of so-and-so's handwritten will. I am familiar with that person's handwriting, and to the best of my knowledge or something like that, this will was done in the handwriting of the person who passed away. So 2 affidavits like that need to be in the probate record. I suppose if someone did question whether that was the deceased person's actual handwriting, then you'd have to have, testimony and all of that. So I've never personally been involved in a situation where somebody died, a handwritten will was presented, and somebody questioned whether it was the actual person's handwriting. Been involved in a bunch of them where somebody died, they had a handwritten will, and it was no problem getting 2 of the children or a surviving spouse to sign the affidavit that it was the actual person's handwriting that they recognize. So I hope that helps. Oh, you're welcome. You're welcome. Happy me. Bring on the live chat. I love the chat. When I see live chat, I stop in my tracks and I jump on the live chat. One of the benefits of doing this YouTube live presentation is, kind of what Happy Me just went through, is he was able to get a question asked and answered. I know I get a lot of questions in the comments to my kind of recorded YouTube videos, but I just, quite frankly, I not that I don't have time, but I don't want to sit down and have to type a response to every comment to a YouTube video. It's just time consuming. It's just not fun to me to sit down and type. And sometimes the questions that are asked in the comments, I don't know the backstory. So if I'm answering a question, I'm just guessing to what the backstory is. All right. So Ron Clark, stopping in my tracks here. That's okay if it's not on the subject. It's related enough. Does an IRA beneficiary distribution fall under the name on the check rule? Is an IRA balance a countable asset for Medicaid purposes? I'll answer the second one first. Is an IRA balance a countable asset? Sometimes people call it a countable resource. Close enough though, for Medicaid purposes. Again, depends on your state. Here in my state of Louisiana, the entire IRA balance is a countable resource of the Medicaid applicant or the Medicaid recipient, even though no taxes have been paid on it, even though it might be in one spouse's name and the other spouse is in the nursing home. None of that matters in my state. I know in other states, I ran across a situation in Tennessee where the rules there were if the IRA is in pay status, I think was the way it was worded, then it's not a countable resource. In pay status meant that the IRA owner was taking required distributions. They were over at the time 70.5, now they'd be over 72, which most Medicaid applicants are going to be, at least older than the required minimum distribution minimum age of what is now 72. So now does the fall under the name on the check rule? And what that means is if you have a married couple, they look at the combined assets of the couple for the asset test, but for the income test, they look at the income that each spouse receives and they look at the name on the check. And Ron, I don't know if you're a lawyer, you've been hanging around a lot. I kind of hope you are a lawyer because you sound like you know enough to be a lawyer. But if you were a consumer, you're a well-educated consumer, and I think you're the one in Wyoming. So love to have you give me a little background there. So yeah, it's that distribution, that required distribution is income, and all income is a name on the check rule. So so that matters if there's an institutionalized spouse and the community spouse has an IRA and they're getting those required distributions. Those required distributions are considered income to that community spouse, which does not affect the Medicaid eligibility of the institutionalized spouse. All right, is it okay to notarize a handwritten will in Louisiana, although it is not required? Good question, Happy Me. Glad to see you're a Louisiana person. Is it okay to notarize it? Well, as the only requirements are that a handwritten will in Louisiana be entirely dated, written, and signed in your handwriting. So having it notarized, it doesn't make it any more valid. And I guess I would say it doesn't make it any less valid, because the only requirement's entirely dated, written, and signed in your handwriting. Now, if there is going to be a notary, there's going to be some, courts tend to try to make wills valid if they can. So sometimes they stretch some of these formality requirement rules because they want the intent of the person who died to happen. So is it okay? It's just not necessary. Okay, maybe, but not necessary. I hope that helps. Okay. All right. So, and again, we've seen a lot of handwritten wills, and the people out there, they got it notarized, they got it witnessed. I don't know that I've ever seen one invalidated because it was notarized or witnessed. It's just not necessary. Okay. All great questions. Love the live chat. Keep bringing it on. Even if you got a great joke, like, I'm not going to hold you to the standard of me and Ron as far as your humor, because we're at that top level. But if you got some humor, you got a joke, whatever, especially if it's clean, bring it on. We'd love to see it. All right. So what I'm going to go do first is I'm going to reveal the 26 states. And I haven't researched every state's law. I haven't really only researched a couple. But so I'm getting this list from other sources. So don't hold me to it, but another source, I guess, did the research and said these 26 states permit handwritten wills. Again, handwritten wills that don't require notary and witness requirements. And I will tell you, in the COVID deal, it was a pretty big deal, especially when COVID was in its early stages of, gosh, what's going on? We don't want to go anywhere. We don't want to be around anybody. We don't want anybody coming to our office. We don't want to go to a store. We don't want to go to an office, but I need to get my will done. So I think probably a lot of holographic wills or handwritten wills were written because and people didn't want to go deal with lawyers and notaries and witnesses. They didn't want to be around them. So 26 states, Louisiana, which is one of the 26 states which permits handwritten wills. We call it holographic will, starts with the letter O. Most of the other states that permit handwritten wills call them holographic wills, starts with an H. So here they are in alphabetical order. I'm going to go through them quickly. You can listen for your state because it'll be alphabetical. So here we go. The 26 states that permit handwritten or holographic wills that don't require notary or witness requirements: Alaska, Arizona, California. California's a big one. Colorado, Idaho, Kentucky, Louisiana, Maine, Michigan, another big one, Mississippi, Montana, Nebraska, Nevada, New Jersey, North Carolina, North Dakota, Oklahoma, Pennsylvania, South Dakota, Tennessee, Texas, another big state there, Utah, Virginia, West Virginia, and last but not least, Ron, Wyoming. All right, so if you're in a handwritten will without the other requirements of a written will, without those other requirements be met. It's not that you can't do a handwritten will, but since it's got to be notarized and witnessed and all of that, then you might as well do the typed up version because that's easier. All right, going back to the history, I think there was a guy, it's a fairly well-known story, guys like Tractor, I don't know what state he was in, but a tractor fell on him. He kind of felt like he was going to die. He was in a state that permitted handwritten wills. He took out his knife or key or something and carved in, I leave my estate to my wife or something like that on the fender of the tractor. And then when he died, they took the fender off and filed it into the evidence records or whatever of the courthouse. And that was his will. So kind of a unique story there. And all right, we went through the states. Also note that within those 26 states, each state has its own rules. I know my state's rules better than in Louisiana, better than I know any of the other states' rules. but you do have to follow your rules. I'll give you an example. Here in Louisiana, to have a valid handwritten will, the only validity requirements must be entirely written, dated, and signed in the testator's handwriting. Testator is the person who wrote the will. So I know that there are other states, because I've looked at them, that they'll consider the will valid if part of it was typed, but the important disposition provisions were in handwriting. And I forget what state it was, but I've seen that, read it numerous times. And so you just have to understand what your state's rules are. All right, so guess what? I have typed up and I printed off what a simple sample handwritten will would look like. So if your situation is complex, you're in your third marriage, you have children from your first marriage, you have children from your second marriage, your third spouse doesn't get along with one or more of your children from your previous marriages, you want to arrange for everybody to be treated fairly, whatever that means. You have heirs that may be disabled or can't handle money, or they may be getting government benefits, or your estate may be very large and have tax consequences. You have many heirs and many different types of bequests. You want to leave some property to some certain people. You want to leave some cash to certain people. You want to be very specific that if certain of those people predecease you, then their share goes to these people, while if these people predecease you, their share would go back to other people, while if others predecease you, their share would go back in the pot, for lack of a better term. All of those things are, don't do it yourself. Too many moving parts, mistakes are going to be made. This sample situation here is, I just want to leave everything to my spouse. And you know what? If my spouse dies before me, because we're about the same age, I want to leave it to my kids equally. And I want to name an executor. So that's a situation where I could see somebody saying, hey, I'm going to do my own handwritten will, because there's not as many moving parts as any of the other circumstances that I just described. So I broke down a handwritten will. And again, if someone does a handwritten will, it should be short, because quite frankly, you got to write it all out. And then two, it should be a rather simple scenario, because if it's more complicated, you're going to get lawyers involved. And when lawyers involved, they're going to use their word processing and their computer software to generate, a will that, comes out through the word processing program. Okay, but nonetheless, in light of all that, in light of the quote that says a person who acts as his own attorney is a fool for a client, here's a sample. And this sample is, I want everything to go to my spouse. And if my spouse dies before me, I want everything to go to my kids equally. And I want to name the right people as the executor. So every handwritten will should have three parts. The first part, and these are my terms I'm making up. The first part is what I call the introduction. And there needs to be an introduction, because every will, you need to state that it's your will. So if you get out a piece of paper and write out, I'd like my son to have my house, and you just leave it at that, that's probably not good enough for him to get your house when you die, because you didn't really declare that was your will. It kind of looks more like a kind of a wish or a request or a statement of your thoughts at that day versus a actual testament. Okay, so at the top of every handwritten will should be a date. I don't know if you're seeing this, but I wrote July 2nd, 2020 at the top. In fact, I did this in a Word handwritten font. I didn't actually write this out. Don't use a handwritten font, because that will invalidate. It actually has to be in your own handwriting. But at the top should be the date that this is being written. whatever that date is. And then there should be this introduction. And the introduction should have two parts to it. And then this is what I call a John Doe example. It says, I, John Doe, declare this my last will and testament. There you go. You've just declared it to be your will. I, John Doe, declare this my last will and testament, revoking all prior wills and codicils. That's another piece of the introduction, because if you have a will that says this, and then there's a previous will that said that, yes, the later one controls, but if the most recent one controls, but if there's, if the most recent one doesn't cover something that the previous one covered, you could have some problems there. So we just say, the new will revokes all prior wills and codicil. A codicil is like an amendment to a will. So you're starting off with a clean slate, revoking anything else that you've done in the past. All right, so that's it for the for the introduction part of the first of three parts of the handwritten will. Second part's going to be the disposition part. How do you want to leave things? And again, if your dispositions are extremely complicated, I will leave $50,000 to my nephew to be used for his college education. But if he's already graduated from college by the time that I pass away, I leave him $10,000. All that stuff is for you to work with professionals and make sure that those moving parts are all covered correctly. But in this one, dear old John, he's got a wife, he's got some kids, wants to leave everything to his wife. And so his will says, very simple, 1, 2, 3, 4, 5, 6, 7. 7 words. I leave my estate to Jane Doe. That does it. After the introduction, he says, I leave my estate to Jane Doe, and couldn't be any clearer or simpler than that. So when he dies, everything he owns is going to go to Jane, who happens to be his wife. Now, because Jane is around the same age as John, he should cover, this contingency of the fact that she might die before him. Heck, maybe there's a 50% chance or so that she might die before him. She's about his age, whatever. I know guys that live a little longer than women, like taking all that into account. I leave my estate to Jane Doe. But since there's a fairly possible contingency that she may die before him, he ought to cover what happens if that's the case. He and Jane have some kids. They want everything to go to the kids. So he's got it covered, not in 7 words, but not many more than that. Next paragraph or sentence, whatever you want to do. So it did say, I leave my estate to Jane Doe. And then after that, it says, if Jane Doe predeceases me, I leave my estate to Peter Doe, Susan Doe, and Joseph Doe equally. That's their 3 kids. So there you go. I leave my estate to Jane Doe. Simple enough. Goes to her. She dies before. Says if Jane Doe predeceases me, which let's say she did, I leave my estate to Peter Doe, Susan Doe, and Joseph Doe equally. Goes to the 3 of them. Now, that's it for this oligraphic will's disposition provisions. Sometimes we get the question, what if Jane dies before me, my wife Jane, and what if my youngest son Joseph dies before me? And then what happens? Well, you can always redo your handwritten will, but I will tell you, I know here in Louisiana, if dad left everything to his 3 kids and one of his kids happened to die before him, if his kid Joseph had kids, Joseph's part would go to Joseph's kids. So that happens under our kind of what happens if a legacy lapses, as we call it in Louisiana. And every state, again, may have different rules. But sometimes people cover those contingencies specifically in their will. Sometimes the law addresses it correctly if it's not covered. And sometimes you need to cover that contingency, and sometimes you need to redo your will when there's a major change to the family circumstances. So be aware of all that. So now we're done with 2 of the 3 parts of a handwritten will. The third part is the executor appointment. So I have three parts to my executor appointment. And under the normal scenario here, this is where John said, like most married people do, it says, I name Jane Doe as my executor. Yes, I could have used the word executrix, female. I think executor is standard enough to where, I know it's standard enough where it applies whether you name a male or a female as the executor. You don't have to list executrix if you happen to list a female as that representative. So I named Jane Doe as executor. And then because Jane, in fact, we always suggest that you name a backup executor. And in this case, it says, I named Jane Doe as executor. I named Peter Doe, who was the oldest child, I named Peter Doe as alternate executor. So that's the second part of the three parts of the executor appointment. First one, I named Jane Doe as executor. Second part's backup. I named Peter Doe as alternate executor. And the third part, my executor may act as an independent executor. A state issue in Louisiana, if you state that your executor can act as an independent executor, they'll be able to take more actions without having to get a judge to approve each of those particular actions. So pretty much everybody wants their executor to be an independent executor. It's less court supervision over the settling of the estate. And then there's the last required, very important, signature of John Doe at the end of the testament. So there you go. I'm kind of looking at date, first part, declaring it's the will, revoking prior wills and codicils, dispositions, leave estate to Jane. I think you're reading it backwards, maybe. If Jane predeceases to the kids, final executor appointment, named Jane. Peter as alternate executor, may act as independent executor. For some couples and families, that'll do it. And then based on the question we had earlier from Happy Me, after John dies, maybe Jane, maybe one or more of the kids will sign these two affidavits that are required where they indicate that they recognize John's handwriting and that's his will. Okay, so there you have it. Again, my final disclaimer, if your situation is complicated, unless you have confidence that you know what you're doing, get some real help, some professional help, some attorney help. But I just know there's a lot of people out there who say, I'm going to figure this out myself and I'm going to do it myself. I don't want to have to pay a lawyer. I don't want to go to lawyers' offices. I don't have time to do it. I don't want to do it. I'll do it myself. Blah, 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 blah. So there you have it. All right. Tomorrow, it's all about protecting the home. If somebody goes into a nursing home, the mistaken assumption is the end. People think it's the end all rule when they hear that the home is not a countable resource for purposes of Medicaid eligibility, but it goes way, way beyond that. Thanks, Ron, for letting us know. I saw the first line, longtime tax accountant. There's many, many clients that are all asking me all these questions and need my help. I'm getting, congratulations. I'll have to print out a certificate for you for your estate planning PhD from the Rabelais branch of LSU. Yeah, go Tigers. Okay, so yeah, now it makes sense to me. What's the difference, Happy Me, between an independent executor and simply executor? How a son who is a beneficiary be independent? Good question. All right. So let's say in the will, it says that Peter, the son, he's one of the heirs, but in the will, it says, my executor may act as an independent executor. All right, so if in the will it says the executor may act as an independent executor, now Peter, as the executor, he'll become the executor, and because he's independent, he will be able to do things like sell John's home, pay John's electricity bill on his house, sell John's vehicle. he'll be able to do all of those things without having to get a judge to sign off and approve his doing each of those acts. If it says he's just the executor and it doesn't say he may act as an independent executor, then and he'll become confirmed as the executor. And then when he tries to sell the house on the estate, or when he has to pay bills on behalf of the estate, he will have to submit a petition and get a judge to approve those acts prior to him taking any act. So I hope that helps. If it says he's the executor and it doesn't say anything in the will about him having the authority to act as an independent executor, then all of the heirs could sign an agreement allowing Peter to be an independent executor. So if everybody gets along, they typically do that. But if there's one of the heirs who doesn't trust Peter, then it's unlikely that that heir will sign the agreement to allow Peter to be the independent executor. You're very welcome, Happy Me. Just you got a great name there, great YouTube name for what that's worth. Okay, so yeah, tomorrow, too many people mistakenly make the assumption that, hey, we don't need to do anything with the house because it's not a countable resource. Ding dong, you're wrong. There's all kinds of problems with the house from a transfer standpoint, from the state or Medicaid getting it using their estate recovery rights after the Medicaid recipient dies. And there's other ways to protect the house, and then there's houses with mortgages and reverse mortgages and all of that. So it's really an important topic to address. So we'll be talking about the house and Medicaid tomorrow, as part 10 will be halfway through, kind of, it'll be over before we know it. I'm going to miss all of you when we finish after 20 episodes, but we still got 11 more to go. So y'all take care, be safe. Bring on your jokes tomorrow, 10 a.m. Central Time. Have a great Sunday. See you next time.